First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have two cases on the docket scheduled for oral argument this morning. Our first case is Eric Oagate, I believe, versus State. Counsel, you may approach.
Thank
Counsel,
you.
we will allocate you 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, sir. Can I please reserve 3 minutes of time for rebuttal?
So noted. You may continue.
May it please the court, my name is Luke Newman, and I represent Eric Oagate. I want to start out by...
Can you pronounce his name again?
Oagate
you.
is the version that we're using, at least in my office. I want to start out by talking about something about which the state and I agree. The state and I agree, through the briefs in this case, that the state government, when it's prosecuting a citizen, may not intentionally elicit the fact that the citizen has hired an attorney. That's what happened in this case, and that's why this case warrants a reversal. In cross-examining a defense witness, the prosecutor, Mr. Oagate's prosecutor, held a deposition transcript in her hand. The deposition transcript is part of the record in this case at this point. It's 27 pages in length. 2 times in that deposition transcript, the witness who's being cross-examined pre-trial had said, I confronted Mr. Oagate with these allegations, and he told me he needed to talk to his lawyer. She said that twice in the deposition transcript. The prosecutor...
Why aren't you arguing more broadly? I mean, the trial counsel objected to this questioning several times as being beyond the scope of direct.
Yes, sir.
And there are a number of responses given by the witness that were pretty damning for your client, I would think, beyond just the attorney reference. I mean, she's talking about these other allegations, and it's sort of the broader context. But you're not arguing whether any of that was the broader picture, whether that was error, that was prejudicial.
I agree with that.
You're just focusing on the reference to the attorney?
I agree with that. They haven't directly briefed those issues, that the objections based on this line of questioning that related to my client's statements was outside the scope of direct. So I agree with that there, but I think that helps us paint a picture, because later on we have this counter-argument from the state in this case, in which the state says defense counsel chose not to object, right? And then when we go back and we look at the transcript of the cross-examination, when the state went away from the timeline defense, which is the reason the defense attorney put this witness on the stand, was about this timeline defense, that there's this allegation that Mr. Oagate abused me, and after I was assaulted by him, I ceased babysitting for him. I didn't want to have contact with him, and I didn't spend time alone with him. His child came to my house, and I babysat the child there. And then through the course of the defense cross-examination in the state case, the defense counsel gets out through the alleged victim's stepmother or father, the CPT interviewer, that didn't happen, that this individual kept having contact with Mr. Oagate, including going to the home where she's saying that she was abused, right up until the time she made these allegations. And so I think that frames why it was important for the defense counsel to then call this other witness, who I refer to in my briefs with their initials, L.A., and to call L.A., who's the alleged victim's aunt, and who's not just an aunt, but an aunt who had raised the alleged victim as if she were a mother figure. She referred to her as mom, in order to get out this information that this alleged victim, who's saying she was abused and then cut off contact with Mr. Oagate, continued to have contact with him, continued to babysit for him, continued to go to the home right up until the time these allegations came out. At that point, then we switch, obviously, and then we get into cross-examination. And the state on cross-examination, and the transcript's clear, the state has in its possession this transcript of the pretrial deposition. The state then tries to get into these statements that Mr. Oagate had made to that witness.
But the it felt like I know what the prosecutor was doing when doing the cross-examination of the defense's witness, which I suspect was called for a very limited purpose, and was very careful to ask some very limited questions And then the prosecutor gets up on cross and opens it up and then starts talking about the Vaseline and sexual relationship and all this other stuff, including, her coming to him and making all these other allegations. Another one is coming forward, and then that's what elicited the response.
Correct.
About, oh, no, I need to call my lawyer.
Correct.
In that context, wouldn't almost anyone respond that way when faced with those kinds of allegations? You should probably contact a lawyer at this point.
I agree with that.
But that's not a suggestion that he's guilty. It's just a suggestion that's a natural reaction in the context of these larger questions that you're not suggesting were harmful error in this case.
Well, I think that the harmful error was not. I think that the harmful error was sniffed out by the defense lawyer, who then made the scope objections. And I agree. I have not briefed out specifically that trial court abuses its discretion in overruling the scope objections. But that's what led up to this. And I think this bleeds into another issue, a counter argument issue. If we hear later, again, we didn't hear this at trial again, because as soon as this came out, timely motion for a mistrial and objection were immediately made and argued, and then renewed overnight because we had an overnight recess. And
what was the basis for counsel's motion for mistrial?
Sir,
what was the basis for counsel's motion for mistrial?
The counsel said you knew that response was coming, and he said this, if we look at the transcripts, multiple times. You knew that was the answer you were going to get to that question. And he said, you elicited a comment from this witness on my client's right to be represented by counsel. And he said it immediately when it came out. They argued about it at sidebar, and then we had this state argument that, well, it's different because it's not a law enforcement witness. And the judge actually said, the trial judge said, well, my ruling would be different. I'd give you a different ruling if that witness on the witness stand was a law enforcement officer. But because it's just a citizen and not a law enforcement officer, the trial judge said, I'm overruling. And then we got into an evening recess where the trial broke, and we were going to come back and do closing arguments and jury instructions and deliberations the next day. And during the evening recess, counsel filed a written motion for mistrial and said, I want to readdress this issue. I was told at sidebar that the basis for the ruling was that the witness was not a law enforcement officer, but instead a citizen. But here's this case. He cited the Lenz case. And he said, here's this case. That's a distinction without difference. So then when trial reconvened in the morning, the parties were together in court. And at that point, the argument shifted. And what I was getting at, though.
But did counsel specifically argue that this testimony violated his Fifth Amendment right against self-incrimination?
He said it's classic grounds for mistrial to speak on my client's right to counsel, was the language that came out of his mouth. And I quoted the argument in his argument at sidebar when he originally made the argument, and they had the sidebar on, let's call it day one of the trial. And then that night, he filed a written motion for mistrial. And I just have to refer you to the record on that. I don't know exactly what that motion said, but he said it's classic grounds for mistrial for that witness to speak on my client's right to counsel. And what we get then.
But it is a fact that citizens have a right to counsel. So I don't understand what the prejudice is to have it mentioned that someone may want to consult a lawyer when they have a legal problem.
Well, I then want to get back into that starts where we get back into the.
I mean, isn't it a relevance thing more than anything else, and not a due process?
So the right to counsel and the right to silence issues have been kind of melded, and I would submit it comes from this Wainwright v. Greenfield case, which is a 1986 case from the U.S. Supreme Court. So these two issues are melded kind of when they come up in something like this gets said at trial. And then, yes, what you get into is, I think what we get into is whether or not it's relevant. And so in the limited instances where it's relevant, that it's in the case, and one of the cases cited in the state's answer brief referenced like a self-defense case where silence then would be inconsistent with the claim that somebody, he threatened me, and so I shot him in self-defense. And so in those limited circumstances, it can come in, but it's irrelevant because if you have a right to counsel, you have a right you don't have to, bear witness against yourself. And these are the rights in the Bill of Rights. It's an assurance that's been made to you as a citizen by the executive, then to have the executive stand up in your trial and say, aha, he hired a lawyer, right? It's irrelevant, it's prejudicial, and it's comment on this fundamental right from the Bill of Rights. And so it is classic. I agree on some level. And with how the trial lawyer in this case phrased it when he said, that's classic grounds to have a mistrial. You intentionally elicited from this witness that, he had hired a lawyer. And so then we get into this other issue, and I want to make it clear, we get into the issue on appeal because it was not raised during the trial. And sometimes when there's a sidebar conference, you'll have an attorney on either side tell the judge, listen,
For
Your
what
Honor,
it's worth, I also have, and we didn't give ourselves a ton of time in this argument, but and do have some questions about your second issue as
yeah,
well.
absolutely.
But,
Absolutely.
but
Let me say this, and I'll move on to issue number 2. And it's the first issue. We never had the state, beside the sidebar conference with the argument, the other argument the following morning, the state never says, well, you know what, that really just slipped out. That was unexpected. It was unresponsive. That slipped out and it surprised me as well. We never hear that. All right. Now, the Attorney General's office is arguing that on appeal. But despite the defense lawyer in this case at trial multiple times saying they knew that was coming and that was elicited on purpose, the state never once says, oh, you know what, that witness is hard to handle, kind of slippery testimony, and that just got blurted out on us and it was an accident. We never heard that. And so when we consider that counter-argument, I'm asking Your Honors to take a look at the actual question, the actual question where she straight up asked him, did he ever say he didn't do it? Okay, I want to ask Your Honors to consider what you referred to earlier, Judge Tannenbaum, the scope objections leading up to that piece of testimony. And then I'll also ask you to refer to the lack of an argument after it came out that this was inadvertent, that this has slipped out from a witness who's just kind of blurting stuff out there on the witness stand. We didn't see any of those things. And so if we hear an argument later that, hey, this was an inadvertent slip by a witness who was unsophisticated or difficult to elicit testimony from, I'd like you to consider those 3 factors. Let me talk
Counsel,
about,
regarding your second issue, which you haven't addressed
Yes, sir.
yet, did the appellant preserve the second issue for appellate review by arguing below that CH hearsay statements were inadmissible under section 90.803(23) close paren, because she was not the victim named in the charging document?
let me tell you the exact objections that trial counsel made in this case. At first, he said it's not appropriate in this case, and then he said it was cumulative. And then during the trial, when the state sought to introduce those child hearsay statements, what defense counsel said is, I'm renewing the earlier objections as to child hearsay. So those were the exact objections. And that's the extent of the exact objections that got made in this trial. And so what
is it your position that, are you not arguing that her testimony was inadmissible at all? Like that, I mean, the other crimes evidence or Williams evidence or whatever you want to call
the
it.
hearsay about
No. I mean, but she testified. So
Right.
you're not arguing that it was error in any way for her to testify
I agree with
at all
that.
about that. Okay, so now it's just about the stuff that came after.
That's correct.
And is it your position that, well, what's your response to the state's argument that Dupree and the other stuff, that has to do with when they're not a victim at all, and when you have a sex crime victim, that the hearsay comes in as long as they're testifying?
No, I disagree. I disagree with that. I think
And why? What is based on the text of the rule?
Right. I think what the rule has been limited by Dupree and then this court's Sheets decision. So I'm relying on Dupree and then Sheets to say if you have a Williams rule witness, the Williams rule witness, and I'm not objecting to that and I'm not arguing that on appeal, but to go the extra step, the final step, the hearsay from the Williams rule witness should not be admitted based on Dupree and based on Sheets.
I mean, what do you think I mean, it's an unusual rule. So, I mean, generally, the genesis of Williams in the first place actually excluded, it's like, well, as long as it comes in for reasons other than propensity, then it's relevant and it's admissible. And then we have a rule that develops, and then we have an exception to the rule, or a new rule that says, yeah, for certain crimes, it can be for propensity, it could be, you could have a mini trial on this other crime to prove the charged crime, and that's apparently okay. And you're not arguing that that's problematic.
No, I'm arguing that the next the next step, that the bridge too far in this case is then to bring in the hearsay from the Williams rule witness.
So then what is your, let's assume you're right. Let's assume maybe your interpretation of that is the correct one. What's the prejudice? I mean, she's testified.
Correct.
And so, it's just, maybe it's cumulative, but I don't even see you arguing that the cumulative objection here on appeal. So if it's just the hearsay and it was a misapplication of the rule, we're not going to look at the cumulative nature of it, just whether it's hearsay or not. What's the prejudice?
Let me weave it back into the first issue that I talked about earlier this morning. If we look at and we get to a harmless error analysis, I'm going to call the case the Gallo. Okay, the Gallo instructs us that we look at the permissible evidence when we're evaluating, when we're weighing the harmless error. So I'm weaving this back into the first argument that I made to you earlier, that if we look at this evidence, it's impermissible. And if we're going to weigh the mistrial issue, we're constrained, the court's constrained to looking at what was permissible. So if we're going to do the later weighing analysis, then those two issues dovetail with one another. I'm significantly into my rebuttal time. And
Counsel, I will extend your rebuttal time by 3 minutes. However, in reference to your second issue, you argue in support of your argument the Dupree line of cases. Now, did any of the Dupree line of cases involve the hearsay statements of another child victim whose testimony was admitted as similar fact evidence, as opposed to a non-victim child who merely witnessed a crime?
I think that was the Sheets. Didn't Sheets? Sheets is from this court, and so I believe in Sheets, those were the facts. That one of the witnesses was a Williams rule witness, and that they brought in hearsay, and then Sheets argued that, and then so I refer you, if we're looking for that exact same procedural setup, I refer you to Sheets. And Sheets again is from this court, 1996.
Thank you, Counsel.
All right, I would reserve the rest of my time for rebuttal. Thank you.
May it please the court. My name is Charlie Lee. I represent the state of Florida. I work for the Attorney General's office. The first point I'd like to make is that I don't agree with the appellant that the Fifth and Sixth Amendments are melded in this case. There's very distinct rights here, and the Fifth is not at issue. The Fifth Amendment right to remain silent is one that citizens hold against their government, not Ms. Alisaria, who's the person who testified that the appellant asked for his lawyer. So the Fifth is not at issue. The only case that I could find was Nelson, but Nelson clearly states that when a man goes into a bar, doesn't make any statement, the prosecutor brings out to the other patrons about the shooting he just committed. The prosecutor highlights that, and that wasn't an error or a comment on his right to remain silent in that case because citizens hold that against their government. Now, Martinez and Lenz stand for the proposition that the prosecutor should not make a feature out of a defendant's right to retain counsel. That's a sacred right, and in those cases, certainly Martinez, the prosecutor did it when it wasn't relevant and made it a feature of the trial by asking many questions to witnesses and then bringing it up in closing arguments. And the prosecutor shouldn't have done that, and that's not what happened in this case, and I'll get to some of the factual issues of why that's not what happened in this
Before you
case.
get to the factual issues, Counsel, was L.A.'s challenge testimony a comment on appellant's pre-arrest silence?
Ms. Alisaria's comment?
L.A., yes.
Sure, L.A. Yes, Your Honor. No, Your Honor. No, not a comment on his silence. And the reason is because she's not the government, and I think what the prosecutor's trying to, now, this is going into the factual issue, but if we look at L.A.'s testimony, it's a narrative, and it's not prompted by the prosecutor. When she says that, the prosecutor simply says, did you, and I'm referring here to page 210 of the transcript, the prosecutor asked, he didn't say anything over the phone, I'm paraphrasing, and L.A. says that he didn't. But then L.A. goes, the prosecutor says, okay, and then L.A. goes into a narrative that ends with, he said, no, 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 my God, let me call my lawyer. That is not a comment on his right to remain silent. It's showing his reaction to her accusation. And his reaction was not what a normal person would do and say, no, I didn't do that. I don't know what you're talking about. It's, I'm not going to talk to you about it, which is exactly what happened in Nelson. Well, not exactly what happened in Nelson, but in Nelson, the point the prosecutor was making is instead of going into a bar and saying, you know, this shooting happened, I'm not at fault, what normal people would do, he didn't do that. And his reason was he didn't think anybody would believe him. And that's what if the prosecutor intended to get this testimony out, I believe that's what the prosecutor was going for. Now, I also disagree with the appellant's contention that the prosecutor intentionally elicited this testimony about counsel. It is in the form of a narrative. A lot of prosecutors, a lot of lawyers, when a witness, especially a witness for the defense, is speaking freely, well, the tactic is to let them...
Specifically, counsel, what was the prosecutor's purpose in eliciting this testimony?
I don't think the prosecutor did elicit the testimony. I think the prosecutor was ready because the prosecutor had heard the testimony, and the reason I say that is on 211 of the transcript, when the defense attorney, Mr. Akbar, makes his objection, moves for a mistrial, the prosecutor says, well, first of all, this is not a law enforcement witness. She was ready for it, but I don't know that she elicited it. But assuming she did, the purpose there was I believe the purpose was to show that the appellant didn't react the normal way a person would. He didn't deny the allegations. And now, if the witness had been prepared, which would have been the defense attorney's job, she would have been prepared not to say anything about a lawyer. But that apparently didn't happen. It looked like the defense attorney from the transcript, my contention is the defense attorney was much more ready for this comment than the prosecutor was. And almost as if the defense attorney let the witness walk right into the statement. In that way, it almost seems like an invited error, but I can't make that assumption, just like there's nothing in the record to support that assumption. There's nothing in the record to support that the prosecutor intentionally
Was the evidence used as substantive evidence of appellant's guilt?
It was not, Your Honor. It was never mentioned again. It was an isolated incident, and therefore harmless under one of the cases, Shingledecker, that the defense cites in their brief, in their initial brief, where a video was played with the appellant invoking his rights to counsel, his right to remain silent, and there they held it was harmless because it was an isolated incident and not made a feature of the trial. Unlike Martinez, where the prosecutor got up during closing and went on about how Martinez had hired a civil attorney to sue the police department that arrested him and made that an issue, that was an error. Now, there's a key difference in Martinez and Lenz, especially Lenz. There, in Martinez, the defense objected to the cross-examination regarding when the prosecutor cross-examined the doctor to bring out that the defendant had hired a lawyer, the defense objected, and the court allowed it. They overruled the objection. Later on, the defense didn't object when it came out in closing, if I remember Martinez correctly. Lenz, the court simply allowed the trial court to, they allowed the prosecutor to play the jail phone call where the defendant is talking to his wife about hiring a lawyer that knows all the loopholes. That's a totally different, well, not totally, but it's a different standard. It's abuse of discretion whether the court allows evidence in or not, and it's abuse of discretion of whether a court allows or grants a mistrial or not. However, the distinction is a motion for mistrial has to vitiate the entire trial, and it's an extreme remedy, unlike an evidentiary call. And that's the lens we have to look through at this case. The question here is whether a mistrial was warranted over this one comment. And the answer is no. It was never made a feature of the trial. The jury would assume he had an attorney. As Judge Tannenbaum pointed out, for better or worse, the defense attorney allowed L.A. to testify about all these other things that had happened, and L.A. was allowed to testify that there was a prior allegation referring to C.H. So the jury would assume he had an attorney because he already had allegations against him, and later on they would learn that that was true, that there's Williams rule evidence and that he had been charged with another crime. So it wasn't a prejudicial error. It wasn't one that would affect the jury, and it was certainly not an error that, or a comment that would warrant a mistrial.
Can you spend a few minutes addressing this is issue 2, which seems to be taking a back seat on this? Can you address the intersection of other crimes evidence or other bad acts evidence, that rule and that admissibility, and the hearsay exception for child victims?
Yes, Your Honor. As I was reading the last couple of days, Dupree and Sheets, the cases they predate Crawford, and they speak about leading up to Crawford, the hearsay exceptions that are not firmly rooted hearsay exceptions of common law or what have you. They're presumptively unreliable for confrontation clause purposes. That's right out of Dupree. And then Dupree cites Lee v. Illinois and Idaho v. Wright, which are both about hearsay exceptions and the reliability and the fairness of using hearsay. So it's odd that it's in that case, because I was asking myself, why is there a rule that says that a child victim would be more reliable than a child witness? And Dupree even points out that, I'm sorry, I don't believe it is in Dupree, but a child, an adult victim or adult witness to a crime you can't get hearsay evidence from an adult witness. That's just rank hearsay. And that would be more reliable than of a child witness.
But Dupree seems to suggest that the exception in sub 23 is a narrow one.
That's what I was.
And if it's narrow, should we be reading the rule narrowly so that victim means the victim that is charged in the information?
No, Your Honor, that's what I was.
And the reason I asked for the intersection of that with the other crimes rule is, traditionally, like in other crimes, the other crimes evidence comes in for narrow purpose and it's limited. You have a limiting instruction, which was given here in an odd way, and yet here it's then used to backdoor all this other hearsay stuff, basically on another crime that's not charged. Instead of showing propensity, showing for the limited nature that typically this stuff's admissible, and it seems like it overtook the entire trial. Is that allowed? And is there a constitutional component to this?
I don't think so. First of all, it wasn't objected to in the argument in the appellate's initial brief is not that it is limited to whether the rule applies to a child victim or a child witness. And the point, I just want to wrap up what I was saying. I think I was saying it rather clumsily, but Dupree seems to say that child victims are more reliable for some reason than child witnesses, and I'll assume that that's the case. I think when we view it through the lens of a Williams rule victim, if that's what Dupree is saying, Sheets does not shed much light on that.
But counsel relies on Sheets in support of his position. Can you distinguish Sheets from the facts of this case?
Certainly. Here we have, as Judge Tannenbaum pointed out, it's kind of a mini trial. Now, whether that was I think it was fair to the defendant, and I certainly don't think it was a harmful thing. Now, bringing in the hearsay was sort of gilding the lily. They already had C.H. testifying. But all of this
but C.H.'s testimony was actually quite limited compared to the onslaught of the video and the text and everything else that took place right as the state closed the trial. So,
I understand, Your Honor, and I don't know that tactically from the prosecution's point that was the best procedure. But the argument here is not that there was a fundamental error. That's not the appellant's argument. The appellant's argument is limited to that the rule is in Rule 23, it has to be the child victim to get these hearsay statements in. And that victim is listed to the victim, that victim is limited to the victim listed in the information.
She's involved the testimony of a child witness as opposed to a child victim, which
It
we
did.
have in this case.
It says the statements of a child witness who is not the victim under Section 980323. So these are cases where it's just a witness and not the victim. Going back to the point from Dupree, the point of Dupree seems to suggest that child victims are more reliable than child witnesses. That, if that's the case, that's fine for the state's position, because here we have a child victim. We have a victim of the Williams Rule crime that's being used. And
Wait,
it's not
so
just the
you-
Williams
so you-
Rule crime under 90, I know that they
You
brought.
disagree with the statement in the cases that child witnesses of crimes are not victims?
I don't disagree.
Are victims? Actually, that's a statement. That they agreed with Earhart's statement, for better or worse, that witnesses can be victims too.
I agree with that, but victims in a
So you're
different.
making a distinction of type of victim.
I think Dupree makes a distinction implicitly. It doesn't really explain why a child victim would be less reliable. It's speaking in terms of reliability. I mean, they cite Idaho v. Wright and Lee v. Illinois, which are about the reliability of hearsay and when that becomes a constitutional issue. Dupree doesn't shed any light on why a child witness or a child victim would have different levels of reliability.
Especially
And
considering they're both victims, apparently. Just
They're both
different type of victims.
certainly, and that's why the rule in Dupree it really doesn't make a whole lot of sense, but especially applied to a Williams Rule case, because there you have a victim in the exact same way. CH was a victim in the exact same way that AJ was, just in a different crime. And that crime, as the appellant has conceded, was admissible as Williams Rule evidence, is also admissible under 9404C, evidence of past sex crime by the defendant. So that case could come in, and her child hearsay, I mean, she was a victim in that case, and that's why it asks this court to view it all through the lens of Williams Rule and 4042C, and find that no, despite the fact that the hearsay, CH's hearsay, was probably not necessary in this case, it wasn't prejudicial, harmful, or reason to overturn the appellant's conviction. That's all I have. Thank you.
Thank you, counsel.
I would like to address something that I neglected to say when I was arguing.
Before you
Yes,
get to
sir.
that point, counsel, involving counsels or the state's distinguishing sheets from the facts of this case, he noted that in sheets involved hearsay statements of a child witness who was not the victim under Section 98.80323. Will you find any case law where the child victim's testimony was not admissible under the statute in question?
Can I ask you a clarifying question? When you say the child victim, are you talking about the victim listed in the information? Or are you talking about another victim from another case that was introduced during the trial under Williams Rule?
Not the child victim in the case, but another child victim who was the victim of the crime by that defendant.
Okay, so basically what happened here, where we have another victim that comes in and says, I'm not the victim in the charging document, but I'm here to testify under the Williams Rule. And you're asking, I believe
You find
that,
any case law finding that testimony inadmissible?
I believe that's I know that I disagree with the state on this, but I believe that was the scenario in Sheets. And if I'm wrong, maybe I might move the court to ask to submit something on that, but I believe that was the Sheets scenario. Let me talk about.
What about the rule, though? I mean, no one's really talked about the text of the rule here today. In 23 it talks about, it's not limiting, it describes the type of statement, and it has to be by a child victim, describing any act of child abuse or neglect. I mean, you know the rest of it, but describing any act of child abuse or neglect, and so on and so forth. How do you limit that rule? I mean, just the rule itself. I mean, you may disagree with whether that's, you know, a right rule or a fair rule, but it is a rule. And if we're talking about whether it's admissible under this rule, how do you splice that out?
I would splice it out by saying that the Supreme Court of Florida said in Dupree, which is from 1995, that that type of testimony is limited to the person alleged to be the victim in the charging document that the jury's deliberating about.
All right, so is your point then on that, and this is good, thank you. Are you saying then, like reading Dupree, even though the witness who was testifying there was a witness to a crime, the only way you can square Dupree with the rule is if they're describing a basically a sex act or something that otherwise fits within this rule, that if you were just reading it as, well, it's any victim who's describing any act like this, not the person charged, that it should have come out the other way. But the fact that even though they are, quote, a victim, because they're a witness, and even though they're describing something that is otherwise covered under 23A, the fact that they were excluded anyway, it has to be because they weren't the victim charged in the document.
That's how I read
the main
Dupree.
of your argument?
Yes, sir. That's how I read Dupree. I see that I've exhausted my time, and I will be happy to submit Mr. Boisier's case on the briefs that we filed. Thank you.
Thank you, counsel. Our second case scheduled for oral argument this morning is Otis Simpson versus State. Mr. Offerman, you may approach. Again, Mr. Offerman, we have allotted 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
5 minutes, please.
So noted. You may continue, Mr. Offerman.
Thank you. Good morning. May it please the court. Michael Offerman on behalf of the appellant Otis Simpson. The issue in this case is whether or not the trial court erred by denying my client's motion to withdraw his plea that was made prior to sentencing pursuant to Rule 3.170F. Based on the plain language of that rule and the cases that have interpreted that rule, we know that the trial court may grant such a request if there's no justification or no good reason, but if there is good cause, then the court shall grant such a request. And we know the cases say that this rule should be liberally construed in favor of the defendant because the law inclines toward a trial on the merits. And the Florida Supreme Court has actually encouraged trial courts to liberally grant 3.170F motions. In this case, Mr. Simpson raised two grounds in his motion to withdraw his plea. He said, number one, that he didn't understand the collateral consequence regarding gain time and conditional release as a result of being declared an habitual offender. And secondly, he said he didn't understand that he was not going to be able to appeal the trial court's denial of his motion to suppress. Let me begin with the first claim, the first issue.
He was told, though, what the statutory maximum is going to be,
Correct.
Which by definition are going to be higher than what he might serve with gain time, right?
Correct.
Okay, so he pleaded to crimes knowing that his max sentence, assuming he doesn't get any gain time, was going to be X.
He did. But
And I guess you're suggesting that he's also sophisticated enough to understand how gain time works, but but claims to not have known that gain time may or may not apply to an HFO.
no, I don't think that's the claim. I think specifically as it came out during the hearing on the motion to withdraw the plea, as an HFO, he will earn gain time. He can get up to 15% of his sentence off. He has to serve 85%. But unlike non-HFO offenders, once he earns that gain time, he'll be required to be on conditional release. There are some clients, I had a case in front of this court, Jason Reed, who actually choose longer prison sentences to avoid having to have any time on supervision once they are done with their sentence. So in this case, what he said is, I had no idea that ultimately whatever sentence I get and whatever gain time I receive, that I wouldn't simply be released. I would be released and subject to conditional release for the amount of gain time that I earned.
Yeah, but when he pleaded, he clearly was willing to serve the full time in prison.
Sure, but he wasn't willing to serve conditional release time, or that wasn't explained to him in any way.
So you're saying that it was bamboozled in some way because he was unaware of the complexities of the administrative aspects of sentencing with the gain time and whether he's going to be on CR or any of that kind of stuff, or whether he'd even have the opportunity to just spend time in prison for the full amount. And that was, had he known all of that, he would have rather gone to trial?
Again, that's what was alleged in the motion. That what was proffered to the court. The court didn't make any findings that I don't believe that that's a valid basis.
Well, there was no evidence presented to the court, so there's no findings to be made.
Well, that's not true.
There were witnesses that testified?
Defense counsel specifically said at the conclusion of the hearing that I would proffer my client if I will present my client's testimony if you'd like. And the court said, no, I will accept your proffer that everything you've argued to me today is what your client would have testified had he taken the stand. So if there's any dispute about that.
No, I get it.
So this court has to accept, because the court accepted that proffer, that that's the evidence. So defense counsel's argument in the motion and what was stated during the hearing on the motion to withdraw the plea is exactly what Mr. Simpson would have explained. So there is evidence in the record. And if there's any question about that, I've cited to a case in my initial brief that the remedy at the very least would have to be to send this back for a hearing so my client can testify. But in a situation where the court specifically says, I'll accept your proffer and I agree that everything you've said here today would be what Mr. Simpson would have testified to, that is the evidence that's presented in support of these claims. So, yes.
Well, what was also proffered was the communications that counsel had with the family and with the defendant about, pleading and what, all the potential consequences, and, that was all discussed and, in advance. Right? So, I mean, and the court was aware of that as well, that these communications were going on, that it wasn't like it just was thrown at him at the last minute, like, hey, plead or go to trial.
No, this, Judge, literally is a last-minute type of case. There was a jury waiting, and he hadn't even had his motion to suppress heard. The suppression hearing was heard before jury selection.
Sure.
I think it was maybe even heard in chambers.
But what his counsel explained to the judge in chambers was, I'm telling you that I've talked, because he was being, it seemed like a little defensive, because he wanted to make sure the court knew that there were communications with the client in advance about pleading, and that the family had asked about pleading and that kind of thing. And of course, the state had offered a plea deal earlier as well.
Okay, so
it wasn't just sprung on him. This was an ongoing conversation.
I guess. I would step back and let's take a look at our criminal justice system for a defendant who's charged with possessing items that were found in his car. And in a situation like that, the obvious claim is going to, if there is a defense potentially, if there's no one else in the car, is that was there a violation of your Fourth Amendment rights? In this case, there was an allegation that there was a violation of the Fourth Amendment rights, that there was no probable cause to search the car and or any consent was tainted by unlawful authority, so unlawful show of authority. So that's your biggest claim. And a defendant who's facing many years in prison, but at least 30 if you're habitualized, whether the other counts could ever be run consecutive or not, that's an issue. And he has to get an answer as to whether or not his motion to suppress is going going to carry the day, because that obviously would be determinative of whether or not you are going to have to face charges or not. And that motion to suppress is not even heard until after the jury has already come in for jury selection and in chambers the morning of. So then the defense attorney did specifically say he would like more time to consider this, and the judge says, I'm denying that request. You either enter your open plea now or we're going to trial. When he just found out literally a couple minutes before that his motion to suppress has been denied. So yes, I do think this was eve of trial, not even eve of trial, morning of trial, rushed upon him. And I think any defendant in my client's shoes would not have a thorough understanding of all these things. So the allegation is no one explained to him about the collateral consequence of HFO status. That's not been refuted by any evidence that the state has presented. And that's not even the basis as to why the judge denied this. The judge denied this, it's pretty clear from the transcript, that she didn't believe that a collateral consequence would amount to good cause under the rule. We now know, right around the same time that the judge was holding this hearing on the motion to withdraw the plea, that Stewart was being decided by the 4th DCA. And Stewart, the 4th DCA, decided this exact issue. They specifically held that a collateral consequence, in that case being placed on the sex predator registry, does amount to good cause under the rule. And therefore, if you raise that as the collateral consequence that you didn't understand, that requires the court to allow you to be able to withdraw your plea. That's what occurred in this case. But that wasn't the only ground that was raised by my client. The other ground raised by my client is that he didn't understand, and again, under the factual scenario and the procedural history I just gave you, that he was not going to be able to appeal the denial of the motion to suppress. That also was a reason that he should be able to withdraw the plea. The judge below didn't even rule on that. There's no mention by the judge as to why the reasoning that she just ultimately said at the conclusion of the argument, going back and forth on this collateral consequence issue in the HFO, that I'm denying your motion to withdraw the plea.
Well, true or false, did the judge, I mean, yes or no, the judge did tell him in the plea colloquy, you're giving up your right to an appeal.
So let me read that, Your Honor. The judge said specifically, and I'm not sure I understand, you are also going to waive the right to appeal the conviction at sentence to a higher court by entering the open plea. I don't know what the phrase conviction at sentence means. So I'm not sure that my client would have understood from that. I would also say that...
But he would understand the word appeal, right? And he understood, okay, I'm waiving some sort of appeal.
Yes.
But maybe I should ask if I'm unclear.
But we know that's not even, this is not an accurate statement by the judge. You can appeal if you enter a plea. You can appeal the jurisdiction of the court, and you can appeal the sentence. So
you can appeal certain things when you plead, right?
Correct. So does that explain to this? My answer would be no. I don't know what's being explained by this. What I do know is what wasn't said is, do you understand that by entering this plea, the motion to suppress that I denied literally moments ago, you will not be able to appeal? And courts have been clear throughout the state that when some type of waiver during a plea colloquy is going to be found, the waiver must be specific to the issue. So there's nothing in this plea colloquy that would specifically tell my client that by entering this plea, he was waiving his right to appeal the denial of the motion to suppress. The motion to suppress was the biggest issue in his case. So, and I also would submit the idea of when a defendant enters a plea and when he can appeal following that plea, if there's been a previous motion to suppress, motion to dismiss, or other motions, is something that courts are not some judges don't always understand, and many lawyers do not understand. We know in the Rents case, from this court from just a couple years ago, Mr. Newman was the appellate attorney in that case, that this court found that the trial court in that case was wrong to find that the motion to suppress was dispositive. And ultimately, Rents said because the defendant entered his plea believing that he could appeal something, and then the judge was wrong because it was not dispositive, and therefore he could not appeal something, that he certainly, that's good cause, and he should be able to withdraw his plea. So I get calls.
Mr. Efferman, real quick, to the point about when someone can appeal following a plea. I'm curious. So reading the transcript below, defense counsel, went to great lengths to, clarify that this, this is a pre-sentencing motion to withdraw plea, so we're not arguing involuntary. That's not the standard. It's good cause.
Correct.
So when you go to the bases for appealing in 9140B2, it has a very specific list, and one of those is an involuntary plea if preserved by a motion to withdraw plea. So I'm curious, just to confirm our jurisdiction here, if below it was made clear this is not on the basis of it being involuntary plea, what's our basis for jurisdiction? Can you point me to that?
Clearly, a defendant, by filing a motion to withdraw a plea pursuant to 3.170F, has preserved, if that gets denied, has preserved the ability to appeal the denial of that motion. As far as the involuntariness aspect of it, the question, those terms don't necessarily fit to each of those sections. Yes, if a defendant files a motion to withdraw a plea raising good cause, pre-sentencing under subsection F, that would be considered in the umbrella of an involuntary plea. But as far as the standard for showing good cause, courts have been clear that you don't have to show that the plea was not knowing, intelligent, and voluntary, which would be potentially a standard that would apply to a 3.850 motion as to whether or not the defendant has established a manifest injustice to be able to withdraw the plea, or even the standard that would apply in a post-sentencing motion to withdraw the plea. You simply have to show that there's some consequence of the plea that the defendant didn't understand. So from that sense, broadly, yes, it was involuntary because he didn't understand this consequence of the plea, the two consequences, not being able to appeal the denial of the motion to suppress and not understanding the HFO and how it applied to conditional release. But again, you don't simply look to the plea colloquy, was the plea knowing, intelligent, and voluntary? If yes, then you deny it, which potentially would be the standard in the 3.850. No, you have to look to see, is there a collateral consequence such that if it wasn't properly explained and we don't really know, motion to not being able to appeal the denial of a motion to suppress doesn't necessarily fit into the collateral consequence window. It actually is simply if you believed, as this court said in Rents, that you were going to be able to appeal, and if it turns out that you could not, that's a basis, that amounts to good cause, you should be able to withdraw the plea.
But what you don't raise on appeal with respect to voluntariness, which may be more direct, is when the trial judge tells him, look, you have two choices. You can plead guilty and you'll go home today and you'll come back in 30 days for sentencing, or you can go to trial. And he ends up pleading and then goes to jail immediately after that instead of going home. But that's not raised. That seems closer to a voluntariness argument than saying that the defendant sat there, had a bunch of questions asked of him by the judge. He doesn't ask a single question back to her, saying, well, I'm confused about something, or like, wait, you mean I give up all my appeals? Like, I can't appeal my motion to suppress? Isn't that insulting to the defendant, like in his, sort of his ability to be cognizant of things and ask questions for himself?
Obviously, I see I'm in the rebuttal time. I'm hoping I can answer your question and still have rebuttal time. Obviously, I'm stuck raising the exact claims that were raised in the motion to withdraw the plea. Anything that I would raise beyond that, the state would say is not preserved and it'd be correct. And I'd also point out, Judge Norby, the state hasn't argued that this court doesn't have jurisdiction to consider this case. This case is identical to the posture as the 4th DCA Stewart case. If you raise a motion to withdraw a plea under subsection F, then that's denied, and you rely upon a collateral consequence, that amounts to good cause, and you should be able to withdraw your plea. So, Judge, I think, yes, there could be other things that would have also supported this being an improper plea or an involuntary plea, but the two grounds that were raised, each by themselves and certainly combined, established that my client has established good cause, and under the rule, that means the motion to withdraw the plea had to have been granted. Again, the judge didn't even address the motion to suppress issue when ruling on this, and because the specific question wasn't asked, do you understand that you're waiving your right to appeal the denial of the motion to suppress? And that was the only thing that was on my client's mind, and thinking, oh, I've just lost this motion to suppress, I'm going to enter a plea, but I still might be able to appeal that. Absent that being asked, the plea colloquy does not refute my client's allegation, and therefore he does, in fact, pursuant to Rents, because he misunderstood whether he could appeal that, that's a valid basis to withdraw the plea. I see that my time is up. Thank you.
Thank you, counsel.
Good morning. May it please the court. My name is Christy Reagan, and I represent the state in this case. The appellant argues two reasons why he should have been permitted to withdraw his pre-sentence plea. First, he alleges that he was not told that upon earning gain time as a habitual felony offender, and after serving at least 85% of his incarcerated sentence, that he would be released on conditional or supervised release. However, under Chapter 947 of the Florida statute, conditional release is an administrative order or an administrative grant. With it being an administrative grant, it is not a right that the appellant is entitled to. Therefore, because it is an administrative act of grace, it's not a sentence that has been imposed by the trial court. It's not a punishment or an enhanced sentence at all. It is simply a de minimis collateral consequence.
How is it even a consequence? I mean, what's the consequence? I plead guilty, it's a max of 15 years, and maybe administratively there's a chance I serve less than that. And maybe there's a chance that I serve even less than that if it weren't the particular crime that's enhanced with an HFO. I know that the outer range is I'm going to be serving 15 years in prison, just as a for example. How is it a consequence, I guess?
Well, that is why we term it a de minimis collateral consequence. It really is not a consequence. Under conditional release, he still is able to earn gain time. It does not affect his direct sentence at all. So the crux of the appellant's argument is that he does not like the fact that upon being released early from prison, the remaining 3 years are going to be under supervision while he completes the total 20 years of his sentence term.
Do you consider him as having pleaded guilty to being an HFO? Or did he plead guilty to the underlying charged offense?
I would say that he pled guilty to being an HFO as well, because the state did file notice of intent to classify him as such.
Sure. But most of that, has to do, do you consider HFO to be an element of the offense?
I'm sorry, can you repeat?
Is HFO an element of the underlying offense? He was charged, he wasn't charged as being an HFO, he was charged with a significant crime.
That is correct. He was not charged with, HFO itself is not a charge
Right.
or an offense. But in light of him knowing that that was a possibility that he would be classified or designated as such, he was aware of it when he pled to the charges.
And HFO is an enhancement, right?
Yes, it is an enhancement.
And he knew, no one hid the enhancement from him when he pleaded guilty.
No, it was not, and it was not hidden from him at all, and actually, conditional release affects those who aren't even classified as habitual felony offenders. It will affect any inmate who has been convicted of a crime that's in the categories 1 through 4, so it would include those inmates who are in for murder, manslaughter, sexual offenses. So it's not like just by being classified as HFO, you are the only ones who are subjected to the conditional release.
Which do you think is a bigger collateral consequence, a sentence enhancement because of HFO, or maybe your gain time down the road may be affected, or you might get CR?
The sentence enhancement as being classified as HFO.
That seems like a big consequence of me pleading guilty with the HFO on my head as well, right?
I agree. It's the consequence that an individual should be made aware of prior to them being able to intelligently and voluntarily enter into a plea.
What about the motion to suppress, though? The judge only told him that he gave up he waived his right to an appeal, I guess, I don't know if the court reporter just took it down wrong, but it's an odd phrasing, but there was a mention, it had the words in the sentence, waive and appeal conviction. Was that not enough? Was that not enough, I guess, is the question.
Well, during the plea colloquy, it was the appellant who had the burden if he did not understand something that was mentioned. If he was under the misunderstanding that, hey, my attorney told me that I can appeal this issue, however, you're saying that I cannot appeal this issue, it was his burden to address that with the court at this time, or at that time, as to any misunderstanding or any clarification that he needed. So he did not do that. So now he can't sit by and not understand something, only to try to come back and attack and use that as a later reason to have his pleas withdrawn.
Sir, is that the state of the law right now, that the burden is on the defendant to ask follow-up questions if he doesn't understand. And I don't mean, that's not rhetorical, I don't mean it to sound like I'm not cross-examining you. I just, seriously, is that the state of the law right now?
I believe that it is. I do not have the case, but a defendant cannot sit by and idly, know that something is not right, or that he does not understand something, only to kind of keep quiet and want to use that later as an attack for his advantage or his or her purpose.
Is it a plea soliloquy or is it a plea colloquy?
A plea
You don't-
colloquy, did I
okay.
say?
No.
Oh.
I'm making a distinction. Is the role of a plea colloquy to have a back and forth between the defendant and the judge? Or is the point to allow the judge to give a soliloquy and just sit there and explain to the defendant without interaction, here's what's going to happen, here's what you're giving up, and how do you plead?
It is a colloquy because the defendant in that position has to acknowledge whether they understand what they are actually intending to plead to. So it's a back and forth discussion between the trial court or the judge and the defendant. And it is the state's argument that because conditional release is a de minimis collateral consequence, attorneys are not obligated or required to be able to inform their clients of every conceivable collateral consequence. So, excuse me, the appellant's first reason does not rise to the merits of showing good cause. As to the appellant's second argument that he was under the misunderstanding that he would be able to appeal the motion to suppress, that is refuted by the record. As we just spoke of, the judge asked the appellant, do you understand that you are giving up the right to have a jury trial? Do you understand that you are giving up the right to put on a defense? Do you understand that you are waiving any right to appeal? Of all of those, the appellant affirmatively answered, yes, he understood that. So again, if he did not understand something, it was his responsibility at that time to inquire further, or even to speak with his counselor, his defense counselor, and he did none of that.
Did the judge ask the defendant that question? Do you understand that you're waiving your right to an appeal at sentence, your conviction?
The judge did.
Or ask it in some such way that it elicited a response from the defendant in the affirmative or the negative?
Yes. Yes, the specific terming that the judge used was, you're also going to waive the right to appeal the conviction that's sentenced to a higher court. So I'm not sure how much.
Did he respond to that?
Yes, actually, the defendant responded to all of the questions asked of him. Yes, ma'am, I understand. So there was a response in reference to each question that was asked of the judge.
Counsel, if I may digress back to the first issue. Counsel for the appellant relies on the 4th District's opinion in Stewart versus State in support of his argument that the failure to inform appellant of collateral consequences of the plea warrants reversal. Can you address that issue? In other words, distinguish Stewart.
Yes, Stewart is distinguishable from the present facts that we have in this case. Although the 4th District did use the terminology collateral consequences, I think the analysis that the 4th District used, as well as the content and context in which the terminology was used, is very important. In essence, all of the cases listed in Stewart for their reliance on their position was in reference to counsel that had misadvised their clients on collateral consequences. So we know that while an attorney does not have to inform their clients of any perceived collateral consequences, if that attorney steps into a voluntary role to advise their client of the collateral consequences, the advice that is given to their client must be accurate, it must be correct. And therefore, the cases in Stewart, they dealt with counsel misadvising on these collateral consequences. Also, the analysis of Stewart deals with the incompleteness of the plea agreement that Stewart entered into. It was a negotiated plea. However, it did not list that that Stewart was going to be on probation, and we know that that was a condition of him entering into a plea. It also did not mention that he was going to be designated as a sexual predator. Yet 1 month after he entered into the plea, that is the classification that was deemed to him. It also had the term register in the plea agreement. And defense counsel acknowledged to the court that he did not know what register meant. He did not know what it entailed. So actually, the trial court provided several continuances to allow for defense counsel to obtain this information to be able to relay to Stewart, his client. So in the totality of all of that, in the analysis of the 4th District, again, though they use the term collateral consequences, the analysis shows that some of the consequences that were discussed, such as a incomplete plea agreement, those are direct consequences.
Ms. Reagan, just because I'm curious, does the state agree with Mr. Ufferman's position that the pre-sentence motion to withdraw a plea that was filed here is sufficient to fall under the umbrella of asserting an involuntary plea such that we would have jurisdiction?
I do believe that based upon Rule 3.170F, it does fall into that umbrella where jurisdiction is permitted.
Thank you.
Wait, why does the rule answer the question?
I'm sorry?
Why does the rule answer the question? You answered the question about jurisdiction by citing the rule, and I'm curious why you think that that suggests that the rule and our jurisdiction are coextensive.
Well, because,
Are they?
I'm sorry.
No, I mean, so if you file a motion to withdraw a plea, does that satisfy 9140, which requires that the motion, that the ground for appeal be that the plea was involuntary? In other words, filing for a good cause motion, is that the same as asserting involuntariness? And is it a qualitative analysis for purposes of jurisdiction? Do we look at the motion and make an assessment whether they're really arguing whether it is voluntary? Or is it enough that there's a motion filed and heard?
I would lean towards that because the motion has been filed. You're not looking more so towards whether it was involuntary or not. Just the fact that the motion has been filed to preserve the issue.
Could there be reasons, could there be reasons that one would assert in a motion to withdraw a plea for a good cause that don't involve involuntariness?
Could there be a motion filed that does not involve involuntariness?
Sure.
I think that there could be.
So then, why would it be coextensive? So, I mean, if, someone files, let's talk about this case. Let's say, we read the motion and we read what transpired, and he didn't understand, he wasn't aware that there would be all these complexities with the administrative side of things, and had I known, or maybe something more simple, look, Your Honor, I was tired that day or something like that, and I've talked with my lawyer some more, and I now realize I've changed my mind. Is that a voluntariness argument? I mean, it's maybe a good cause thing, and that would be up to the trial judge, but is that a voluntariness argument? Would that argument be enough to give us jurisdiction?
If he is saying that he did not understand, that could be an involuntariness issue.
Or maybe he realized maybe he did think he understood, and then he talked to his lawyer some more, and he comes back and says, okay, I've talked to my lawyer some more, and now we think we have some defenses. I want to go to trial.
Well, has the trial court denied that motion or in?
Sure. Right. He makes the motion, is denied, and he then goes to sentencing. Is that enough to preserve do we have jurisdiction to consider that argument? It's maybe a good cause argument, but not a voluntariness argument.
I still think that you do.
Okay.
Or that there is jurisdiction.
Thank you, counsel.
Thank you. If there are no further questions, for the reasons stated in the answer brief as well as current argument, we would ask that this court affirm.
Thank both counsel for their respective oral arguments this morning. This concludes our oral arguments for this morning. We are adjourned.
All rise.
That's tough. Jurisdictional question. That the court would maybe